Hi guys, and welcome to another episode of Attorney Job Vlogger, Law for the Everyday Layman. Today we'll talk about the topic of partnership, specifically dissolution, winding up, and termination. Okay? So if you like my videos and you want to see more, please hit the subscribe button. Also, please remember that this is only for educational purposes and is not a substitute for proper legal advice or for studying and understanding the law. Okay? Now we go into the final stages of the partnership life, namely dissolution, winding up, and termination. So what is dissolution? Okay? It is simply the change in the relation of the partners caused by any partner ceasing or stopping to be associated with the carrying on of the business. Okay? It is that point in time when the partners cease to carry on the business together. Okay? The significance of dissolution is that no new partnership business should be undertaken, okay? But affairs should be liquidated and distribution of the partnership interest should be made to those who are entitled thereto, okay? In other words, the partnership continues until winding up is completed. Now, what is winding up? Winding up is the process of settling the business or the partnership affairs after dissolution, okay? Which is different also from termination, okay? Termination is that point in time when all the partnership affairs are completely wound up and finally settled. In other words, termination marks the end of the partnership life, okay? So those three stages are different, no? Dissolution, winding up, and termination, okay? Because Article 1828 of the Civil Code states that dissolution must be distinguished from winding up, okay? And 1829 states that on dissolution, the partnership is not terminated but continues until the winding up of the partnership affairs is completed, okay? Dissolution does not automatically result in the termination of the legal personality of the partnership, nor the relations of the partners among themselves. Okay? These partners, they will remain as co-partners until the partnership is terminated. And when is it terminated? When the winding up process or distribution and settlement of affairs has been completed. Okay? Now, the partnership, although it has been dissolved, it continues to exist for winding up to take place. And after winding up is completed, the partnership is terminated. But take note that even if a partnership is dissolved, the same partners may form a new partnership to continue the business under the same terms. Okay? Now, let's go into the causes of dissolution. Dissolution may be extrajudicial or judicial, okay? When we talk about extrajudicial dissolution, the enumeration provided for by law is exclusive and any other ground is not a legal cause for dissolution, okay? And these grounds provided for by law will also result in the automatic dissolution of the partnership. Now, let's go through the grounds one by one. Okay? Under extrajudicial dissolution, no, this can take place either without violation of the partner's agreement, meaning the contract of partnership, no, in which case it is voluntary, or it can take place in contravention of the agreement. Okay? It can be either without violating their partnership contract, or it can be in violation or in contravention of the partnership contract. Now, when it comes to the causes of dissolution without violating or contravening the partner's agreement, we have the several grounds, no? First, of course, we have termination of the definite term or completion of the particular undertaking which is specified in the agreement. Of course, if that happens, then there is no violation of the partnership contract. Second, in case of a partnership at will, no? If it is dissolved by express will of any partner in good faith, okay? If there is no definite term or particular undertaking. Take note, however, that if a partner leaves in bad faith, the partnership will still be dissolved, but the partner who dissolves the firm may be liable for damages because of his bad faith. Okay? Next ground, by express will of all the partners who have not assigned their interests or allowed them to be charged for separate debts, either before or after the termination of the term or undertaking. Now, for this to work, the agreement to dissolve must be unanimous and not just a majority, okay? But the consent of those who have assigned their interests or had their interests charged is not necessary to affect dissolution, okay? Because their interest is no longer with them anymore, meaning the interest in partnership, the remaining partners in that case may simply dissolve the firm, okay? The next ground, without violating the partner's agreement, would be by expulsion, when a partner is expelled, by expulsion of any partner from the business bona fide, in accordance with such a power conferred by the agreement between the partners. In other words, the agreement must have granted the power to expel to the partners, because if a partner is expelled in bad faith, there can also be an eventual dissolution because there will be apparent lack of confidence, but there may be liability for damages in case of bad faith in such expulsion. Okay? Now, if the partners continue the partnership after the term or undertaking has arrived or has been completed respectively, then it will become a partnership at will. I discussed this already in my previous episodes, So that's it for the causes without violating their agreement. Now let's move on to the causes for dissolution in contravention of the agreement between the partners, or the partnership contract. Okay? So, in case of contravention of the agreement between the partners, where the circumstances do not permit a dissolution under any other provisions in this article, then the partnership may be dissolved by the express will of any partner at any time, and this is available even if the partnership was entered into for a definite term or undertaking. Okay? And this can be done at any time and for any cause without the consent of the other partners, because a partner cannot be compelled to stay in the partnership. However, take note, okay? If a partner unjustly or without justifiable cause dissolves the firm, he may be liable for damages. Take note, may. Okay? Depends on the circumstances. Okay? So, those causes that I have previously mentioned are voluntary causes for dissolution because they come out of the impetus or the will or the desire of a partner. Now, we'll go into the involuntary causes for dissolution because they are by operation of law. Okay? First ground here would be by any event which makes it unlawful for the business of the partnership to be carried on or for the members to carry it on in the partnership. Remember, a partnership is a contract, so the essential elements have to be there, and one of those is the object. If you remember in Oblicon, the object must not be contrary to law, morals, etc. Okay? So if the object of the partnership was unlawful from the beginning, the partnership never acquired juridical personality. Or if it was lawful from the beginning, then it becomes subsequently unlawful, then the partnership will be dissolved by operation of law. Okay? Next ground. When a specific thing which a partner had promised to contribute to the partnership perishes before delivery. For you to remember this, just remember res perit domino, which we discussed in sales, In res perit domino, it just means, that the owner bears the loss, The thing perishes with the owner, Whoever owns the thing bears the loss in case of thing, that is lost, So in any case, by the loss of the thing when the partner who contributed it reserved the ownership thereof, has only transferred to the partnership the use or enjoyment of the same. So, under this ground, either the specific thing which has been delivered to the partnership and the partnership is now the owner, it's lost, That's one ground for dissolution. Or in case the partner contributed only the use or enjoyment of that thing, but the ownership is still with the partner, then that will also be a cause for the dissolution. Why? Because what he has contributed, no, whether it be the thing itself or the use or enjoyment, is no longer there. No, the partnership can no longer take advantage of it. Okay? Take note, the partnership will not be dissolved by the loss of the thing if it occurs after the partnership has acquired the ownership of the thing. Okay? The partnership is dissolved because the partner has not or is deemed to have not given his contribution. It's because it will be deemed as the partner did not give what he was supposed to as agreed upon in the partnership contract. Now, if the loss takes place after the delivery of the thing to the partnership, it is not dissolved. No, the partnership is not dissolved. And the partnership will simply bear the loss. Okay? If it is only the use or enjoyment of the thing that is contributed, then the partner owner of that thing bears the loss and he is bound to make good his contribution. Okay? Next ground would be by the death of any partner. No? If a partner dies, then the firm is dissolved. But the other partners can still continue. We'll talk about that later on. No? Next ground would be by the insolvency of any partner or even of the partnership. Why? In the case of insolvency of a single partner, his credit is impaired and it is impossible for him to pay for partnership liabilities in case the partnership assets have been exhausted. Remember that partners are liable pro rata and subsidiarily for partnership debts, no, or liabilities, no, in case the partnership assets are insufficient. So if he's insolvent, he will no longer be able to answer for those liabilities when he is called upon to do so. In the case of insolvency of the partnership, that is a ground because it results in the inability to continue the business, which of course, if you cannot continue the business, that has the effect of dissolution. Okay? Next ground, by the civil interdiction of any partner. Why? Civil interdiction because one who has no capacity to manage his own property should not be allowed to manage partnership property. Okay? Now we can go on to judicial dissolution. Okay? Now, in judicial dissolution, this may be ordered after hearing upon application. Someone has to apply, no? And who can apply? Either a partner or the purchaser or assignee of a partner's interest. Okay? So when a partner files an application or the application is filed on behalf of a partner, the court may order dissolution in the following cases. First, if a partner has been declared insane in any judicial proceeding or is shown to be of unsound mind. Take note, the insanity has to be previously declared judicially, or if not, okay, the insanity must be duly proven. And such insanity must materially affect the capacity of the partner to perform his contractual duties. Next, okay, a partner becomes in any other way incapable of performing his part of the partnership contract. Okay? This should be of such nature that there is very little to no chance that he will recover. Okay? Or he will recover his ability to perform his part. No? Next, a partner has been guilty of such conduct as tends to affect prejudicially the carrying on of the business. Okay? Next, a partner willfully or persistently commits a breach of the partnership agreement or otherwise so conducts himself in matters relating to the partnership business that it is not reasonably practicable to carry on the business in partnership with him. Why? Because the purpose of the partnership is defeated, or it is materially affected, or it's obstructed. Okay? Next ground, the business of the partnership can only be carried on at a loss. Because the purpose of a partnership, take note, again, from the very start, is to earn profit. Okay? and this purpose to earn profit is defeated. That's why this is a ground. And finally, a judicial decree may also be obtained for other circumstances which render a dissolution equitable. Some examples would be abandonment of the business, fraud in management, refusal without just cause to render an accounting of the partnership affairs, etc. Okay? So that's the case where those are the grounds for obtaining a judicial decree when it's the partner or someone on behalf of the partner who files the application. Next, a purchaser or assignee of a partner's interest may also file an application, as I mentioned earlier. Okay? But I will give you the grounds, no, for which he can file an application. After the termination of the specified term or particular undertaking, or at any time if the partnership was a partnership at will when the interest was assigned or when the charging order was issued. Okay? Now, in all these grounds, no, these causes for judicial dissolution that I mentioned, no, why is a judicial order necessary? Why? Because the facts involved in proving these grounds may be open to dispute, no? One party would like to allege it, the other party would like to counter it or defend against it. So there is a need for judicial determination to find out if indeed dissolution is warranted. So we leave that up to the court, okay? Now let's go to the effects of dissolution. Okay? First, with regard, of course, to the partnership existence, no? Is the partnership dead? Not yet, not yet. Because dissolution does not terminate the partnership life. Those are different. In case of dissolution, the partnership continues and its legal personality is retained until the winding up process is completed, and upon which the partnership will only be terminated after the winding up process is completed. Now, another effect of dissolution with regard to the partner's authority to act for the partnership, remember that every partner is considered the agent of the partnership with authority to bind both the partnership and the partners with respect to transaction of partnership business. Therefore, as a general rule, since dissolution results in the partnership ceasing to be a going concern, it also terminates all authority of any partner to act for the partnership or to represent it. Okay? Terminated, no? Wala ka ng authority. You cannot act for me anymore because it's the partnership is now dissolved. Okay? Except in two instances. First, the authority is retained for acts necessary to wind up partnership affairs. Of course, because if you don't have authority, how can you perform winding up? No? So you need authority to wind up partnership affairs, and two, acts necessary to complete transactions which are begun but unfinished. In other words, to complete unfinished business. No? So the authority will only exist. Authority to act will only continue to exist in those two cases. Okay? In other words, no? The right of a partner to bind the partnership to new contracts, obligations, or business is terminated upon dissolution except for winding up or to complete unfinished business. Okay? Now, we'll go into the more complicated parts. Okay? 1832 qualifies that general rule that I talked about earlier into two rules. Okay? First, if dissolution is not by act, insolvency, or death of a partner, okay, 1832, 33, and 34 qualifies that foregoing rule and its exceptions, no, into the following scenario. Okay? First, as among the partners, no, the partners, okay, if dissolution is not due to the act, insolvency, or death of a partner, such as expiration of the term or completion of the particular undertaking, then we follow the general rule that dissolution terminates the actual authority of a partner to undertake new business for the partnership. Okay? Again, as among the partners, if the dissolution is not due to act, okay, someone acting, or due to the insolvency of one partner or death of one partner, then we follow the general rule that dissolution terminates the actual authority of a partner to undertake new business for the partnership. Okay? Now, if the dissolution is by act, insolvency, or death of a partner acted, or he became insolvent, or he died, then the termination of his authority, okay, authority to act, will depend on whether the partner had knowledge or notice of the dissolution under 1833. Okay? And the rules are as follows. Generally, if the dissolution is by act, insolvency, or death of a partner, each partner is liable to his co-partners for his share of any liability created by any partner acting for the partnership as if it had not been dissolved. So in other words, okay, authority is not terminated and a partner can bind the partnership to third persons. That's in general, That's in general. But if the dissolution is caused by the act of any partner, the partner who had knowledge, of the dissolution, or if the dissolution is by death or insolvency of a partner, the partner who had knowledge or notice of the death or insolvency, okay, if he had knowledge, okay, then the authority to act for the partnership is deemed terminated, and a partner cannot therefore bind the partnership to third persons for a new transaction. Okay? It might seem complicated because the words of the law, are precise and they have to explain everything. But just use common sense, okay, to make it easier for you. If you did not know that a partner died, then you can buy the I'll make it simpler again, If a partner did not know that a partner died, then if the partnership in his mind still exists, he has a reason to act and bind the partnership. Common sense. But if he knew that his partner had died, then by logical operation in his mind, the effect of the death of my partner dissolves the partnership. Therefore, I cannot bind someone else. I cannot bind the partnership with a transaction with someone else. Okay? Do you get it? I hope you get it. It's just that simple, Okay. Finally, 1834 governs the rule, gives us the rule with regard to third persons. Remember, upon dissolution, among the partners, the power of one partner to act and bind the partners is generally terminated. Okay, why? Dissolve na kayong firm. You cannot act for something that does not that has no power, that does not give you power, or authority. Okay? Upon dissolution among the partners, the power of one partner to act and bind the partners is generally terminated, but the authority may continue to bind the partnership to third persons who extend credit on the assumption that the partnership is still existing. Why? Because in the absence of anything to indicate the termination of the partnership, it is presumed, it is presumed to exist for the protection of innocent third persons. As such, the law imposes the duty to inform or give notice of dissolution upon the partners to the third persons. Okay? Again, let's make it simpler, A third person, when he transacts business, he does not have to ask all the time, is a partner dead? Is a partner insolvent? And that will result in business getting slower or even stopping, So he has every right to presume that the partnership is still existing. Okay, and if he gives credit to the partnership, then the partnership is bound. This rule is like this to protect innocent third persons who, in good faith, transact with the partnership. Okay? So, it is the duty of the partners to inform that third person, hey, we're dissolved. Why? Someone died, someone's insolvent, someone left, whatever. Okay? That's how simple it is. Okay? So let's break it down into when the partnership is bound to third persons after dissolution and when it is not. Okay? Partnership is bound to third persons after dissolution for acts for winding up the partnership affairs, for acts to complete unfinished business, which is consistent with everything I've been saying. But this is the more important one. The partnership is bound to third persons after dissolution for completely new transactions. Take note, not always. Completely new transactions only if the third person was in good faith, meaning that he was either a previous creditor who had extended prior credit, credit prior to the dissolution, prior credit, without knowledge or notice of the dissolution, okay? Or he is not a previous creditor and the fact of dissolution has not been published in a newspaper of general circulation. Okay? In other words, that creditor does not have constructive knowledge yet. The key here, in order for the third person to be able to hold the partnership liable even if the partnership has been dissolved, is knowledge. Did that third person know that the partnership was dissolved? If he knew, then he cannot hold the partnership liable because he is in bad faith. But if he did not know, okay, and he is in good faith, then the partnership may be bound. Okay? Now, the partnership will not be bound to third persons after dissolution. First, where the partnership was dissolved because it was unlawful to carry on the business, okay? Except of course for acts for winding up. Second, where the partner who acts in the transaction becomes insolvent. Third, where the partner is unauthorized to wind up except if the transaction is with third persons in good faith who have no knowledge of the dissolution. Fourth, the act is not appropriate for winding up or for completing unfinished transactions. And fifth, for completely new transactions which would bind the partnership if dissolution had not taken place with third persons in bad faith. Okay? So in those cases, the partnership is not bound to third persons after dissolution. So how do we apply the rules, If the partnership is dissolved because the term arrives, and it is a partnership with a term, then it is not an act, insolvency, or death of a partner. So if a partner enters into a new contract with a third person, it should not bind the partnership, but only the partner who acted. Why? Because his authority to act on behalf of the partnership is terminated. Okay? Now, if the partnership is dissolved because of the act, death, or insolvency of the partner and the partner had knowledge of this, then the partner cannot bind the partnership also. Okay? But if the partner and the third person had no knowledge of the act, death, or insolvency of the other partner, then the partnership is bound even if the firm is dissolved. Okay? And as I mentioned earlier, notice of dissolution must be given to the following persons. First, persons who extended credit to the firm prior to dissolution. And second, persons who, while they did not extend credit to the firm, they had knowledge of its existence. They know that the partnership exists. Otherwise, if they are not given notice, they shall be entitled to presume that the partnership continues until such notice of dissolution is given to them. Okay? If no such notice is given, the partnership shall continue to be liable to such third persons for acts of any partner within the apparent scope of the partnership business or his authority. Okay? Even if dissolution had in fact taken place until, of course, notice is given. Okay? Now, what kind of notice, For those third persons who had previously extended credit to the partnership prior to dissolution, actual notice must be given. And to all others who are just aware of the partnership existence, simple publication by advertisement in a newspaper of general circulation at a place where the partnership business was regularly carried on, that is sufficient, That will work as constructive knowledge, Now, the giving of such notice, that will terminate the implied power of every partner to bind the partnership or the other partners to new obligations. Okay? Take note also that notice is not necessary in case the partnership is dissolved because it is unlawful to carry on the business or where the partner has become insolvent. Notice is not required in those cases. Okay? Finally, 1834 gives us the rule as to the liability of a dormant or unknown partner, which serves as an exception to the rule that partners shall be liable with all their separate property for partnership liabilities after the partnership assets have been exhausted under 1816. Okay? So if the partner is unknown or a dormant partner, his liability with respect to obligations incurred after dissolution shall be satisfied out of partnership assets only. Okay? Or only up to his extent of his share in the partnership assets. Okay? Finally, let's just talk about the effects of dissolution with regard to a partner's existing liability. The general rule under 1835 is that dissolution does not automatically discharge the existing liability of any partner. Okay? And this rule applies to the continuing partners. Okay? Continuing, those who continue the business. So I'll give you the rules, no? As to the retiring partner or one who ceases to be a part of the partnership, no? He's the one who's leaving, okay? He will be discharged from all existing liabilities upon dissolution only by an agreement between the partner concerned, the other partners who are continuing the partnership, and partnership creditors. Okay? Provided he has given necessary notice of withdrawal, no, from the partnership, a retiring partner will not be liable for subsequent partnership obligations. Why? Because he's no longer a part of the partnership. Kaya huwag mo na siya singilin, di na nga siya kasama. Okay? Now, what if a partner has died? Okay? 1835 provides that the individual property of a deceased partner shall be liable for all obligations of the partnership incurred while he was a partner. Of course, not after, no? While he was a partner. But of course, subject to the prior payment of his separate debts. In other words, the individual creditors of that deceased partner are preferred over the partnership creditors with regard to the separate property of that deceased partner. Okay? So it looks like I've reached the time limit, and I'll just continue the discussion in part 2 of this same episode. Okay? So I hope you may have picked up a thing or two, and I hope to see you soon, guys. Okay? Bye!